Hello everyone, thanks for joining me in this video. The latest move by Nnamdi Kanu clearly expresses he has lost confidence in Justice Omotosho presiding over his case. Having filed a motion on appeal to stay the judgment slated for 20th of November this month, barely less than 7 days today, Nnamdi Kanu have expressed worry over what he appears to be, he considers to be a subversion of justice. Having made 8 prayers or more, which Justice Omotosho failed to review or attend to, he had made several submissions and prayers, but under the supervision of Justice Omotosho, none of these prayers has been granted. You begin to wonder what could have informed the position of the presiding judge. Evidence tendered, submissions made, documents filed, and prayers made in a bid to prove his innocency was turned down by Justice Omotosho. Then what are you basing your judgments? You said you have fixed a date for judgment, and the evidence tendered was not reviewed. The prayers of the defendant was not granted. Now, on what basis are you predicating your justice or your judgment? Invariably, it is very clear there is no fair hearing. An accused should be given a considerable number of time to defend himself and his innocency. But that wasn't the case with Nnamdi Kanu case under the watch or supervision of Justice Omotosho. Nnamdi Kanu have expressed great dissatisfaction and the sincerity of Justice Omotosho to be impartial in that judgment. He has made several submissions, including the witnesses that was summoned. Justice Omotosho maintained that such prayers might not be considered until after the judgment is given. What exactly did he mean, and what is he intending to achieve by this negligence of the defendant's prayers? And this have informed the reason why Nnamdi Kanu has to file a motion on appeal to halt that judgment, because the supposed judgment intended to be given by Justice Omotosho will not be done in good faith if he continue to ignore the prayers he has made before the court. That is quite interesting. And not reviewing the witnesses filed by the prosecution counsel to ascertain whether actually such evidences were substantive and could eventually incriminate the personality of Nnamdi Kanu. Nnamdi Kanu also argued that the court refused, under Justice Omotosho, to review the jurisdiction, whether Justice Omotosho or the court attending to the case of Nnamdi Kanu has the jurisdictional competence to try his case, and on which law is the basis of their allegation against him established. Because without law, there is no conviction, there is no crime. So which crime or which law eventually did Mazi Nnamdi Kanu violate, upon which he will be tried? These are the simple prayers Mazi Nnamdi Kanu made. Unfortunately, Justice James Omotosho have failed to grant those prayers. You must first determine the jurisdiction and the trial. He has asked, you said you are trying me. On what law? On what offense? Because any law is backed up by, any offense is backed up by certain laws within the defined uh, context. So you cannot be judging somebody without any existing law outside the premise of the Constitution and the interpretation of the law. So these are the prayers Mazi Nnamdi Kanu has tendered, but sadly, Justice James Omotosho continued to push them aside, citing that such objections could only be granted after judgment is given. Now, basis? What is the basis of your judgment? You are basing your judgment based on mere hearsay without carrying out due diligence. Such judgment invariably could not be the fault of prejudice. This informed the reason why Mazi Nnamdi Kanu so no, this supposed judgment must be heard, and eventually has approached the appeal court to seek for a motion to suspend the intention of Justice James Omotosho to give a ruling without trial. You understand that? And Mazi Nnamdi Kanu have insisted there is no submission, there is no case against him. If the offense could not be boldly convicted and backed up by law, extant laws, you can't be trying a man or convicting a man on the basis of a law that has not even existed, or a dead or repealed law that is not enshrined, that is not captured by the Constitution of the Federal Republic of Nigeria. So it is unconstitutional. The basis for which Mazi Nnamdi Kanu was alleged or accused has no substance of justice. The law does not expressly accommodate such. And once the law does not accommodate such, it does not exist, and such offense does not exist. As a matter of fact, these are the realities, and Justice James Omotosho must embrace all these realities. You can't say, just as the 2023 election and that of 2015 election in Nigeria, supervised or conducted by INEC. More pronounced is that of 2023, where it is absolutely clear there were gross violations and non-compliance to the rule or the procedures of this election. There are disparities in terms of collection and the rest of them. It is well pronounced. Even a toddler, a child who have not accessed the common basis of education will understand that that is very high level of error, degree of error in that process. Instead of the INEC boss, in quote, Yakubu Mahmood, to review those cases and resolve the discrepancies and the irregularities, he went ahead and announced the result, telling us that he will eventually see to it. How does that happen? Where does that happen? You call yourself a professor, there are discrepancies you needed to reconcile, you need to fix all those irregularities. You went ahead and announced the result. is an act of criminality, and eventually, which eventually the politicians have to exploit. Go to court, and you see the outcome of the court. How could you neglect what you needed to do at the initial stage? And you want to give a judgment without any basis, without reviewing, studying, analyzing the prayers made to ascertain whether the prosecuting counsel have been able to argue their case beyond reasonable doubt. But you just want to, based on your own imagination or possibly whatever may have played out, you want to give a judgment on what basis? And conviction on what basis? On the basis that there is an instant law that was violated, or that backed up the supposed alleged allegation levied against the leader of the indigenous people of Biafra, Nnamdi Kanu. Nnamdi Kanu, all this while, has embarrassed the Nigerian judiciary. And it appears that this Nigerian body of juries appears that they don't know what they are doing, or perhaps are not inconsistent with the provisions of the law. Unfortunately, they should be the ones, the custodians of the law and the Constitution. How could you embrace such level of rascality and perjury? It's sort of unfortunate, and hopefully, if the prayer is granted, of which I strongly believe, and citing these well-articulated positions expressed, you have not determined the case, you have not granted the prayers made by Nnamdi Kanu, and you have not reviewed the trial, and you want to go and give a judgment on what basis? And all the prayers Nnamdi Kanu has made, you continue to press them down, that they should only be called up after judgment is given. Now, when you give judgment on what basis? So you could possibly say you should go and appeal. Why you needed to have done the job to thrash out whatever needed to be thrashed out, to determine in the first instance whether there is any merit in the case against Nnamdi Kanu in the first instance, whether there is any merit, there is any substance of justice, there's eventually any jurisdictional competence or legal rights to even initiate the case in the first instance. And he have also argued that his extraordinary rendition should not be swept underneath, as James Omotosho appears to be pretending, even while there are evidence Nnamdi Kanu tendered in one of his prayers to the court. There is overwhelming evidence of my extraordinary rendition, which the Kenyan court has also ruled and given verdict in that same case. The United Nations, in charge of arbitrary detention and the breach of fundamental human rights, has also made their position very clear. The Supreme Court, of course, the Appeal Court in Nigeria, overwhelmingly discharged and acquitted Nnamdi Kanu. And you being part of the Nigerian juries, pretending not to be aware of these realities, could suspect, could raise certain doubts in the minds of people, including Nnamdi Kanu, on the sincerity and impartiality of James Omotosho to dispense justice. Against this backdrop, of course, Nnamdi Kanu have taken a stand, and eventually such will be granted by the appeal courts. And if that Scaled through, it simply means the supposed judgment slated for 20th of November, barely 7 days today, will eventually be suspended. Well, let's have your own take regarding this development and eventually see what could eventually play out in a matter of days. Whatever be the update regarding this, definitely will be communicated to us via Call with TV. Don't forget to give us a thumbs up, like, subscribe to this channel if you have not done so that you can get our videos once it's been uploaded. Now, the question we must clearly present before Justice James Omotosho: what is the basis of his intended judgment? Why the prayers tendered, presented, made by Mazi Nnamdi Kanu has not been reviewed? The condition of his extraordinary rendition has not been established or acknowledged by Justice James Omotosho led a judgment, or whatever be the case. Could it be any political undertone or any possibility of subverting the course of justice? Well, only time will, of course, reveal otherwise. But depending on whatever happens, definitely Mazi Nnamdi Kanu is not leaving any stone unturned. He's exploiting every possibility and, in fact, engaging the Nigerian jurists very seriously. In fact, Mazi Nnamdi Kanu should be considered a phenomenon, and his ordeal or prosecution within the defined territory or legal system in Nigeria will be something academicians will study in the course of time. How could a man discharged and acquitted continue to be held as a convict? The appellate court of law within the Nigerian legal jurisprudence has discharged and acquitted Mazi Nnamdi Kanu, and yet he's being held. He was not even released before being rearrested. It's, it is a clear affront, a disregard, a disrespect, a suspension, a rep to the Constitution of the Federal Republic of Nigeria that established the entity known as Nigeria and the legal bodies. It's rather unfortunate that this is happening, but Mazi Nnamdi Kanu will definitely get justice he deserves. At the end of the day, the court has upheld his innocency, haven't squashed the count charges against him. So whatever might be the interest of Justice James Omotosho in court for not granting all the prayers he had made before the court of Justice James Omotosho would only be exposed in the course of time. It doesn't matter. Whatever is playing out, the world is watching closely and people are hearing. And Justice James Omotosho should have acquainted himself with the provision of the Constitution. I wouldn't say in any respect that he does not know the law. And the law only permits him to act within the ambit, within the context and the content of the defined jurisdiction of the provision of the Constitution. Outside that, he's more or less being mischievous or not being in terms with the reality. While some have argued that facilitating the judgment without paying attention to those critical concerns or prayers made by Mazi Nnamdi Kanu could be prejudicial, biased, and lacks jurisdictional competence. Possibly, but the time will reveal this. Thanks for watching, and let's have your own take expressed via the comment section.